They go to presidentuniverse.com or andrewconboy.president.com. Check out my live streams. I'm going to go over Constitution, the Backslide Dictionary. Okay, Constitutio, Latin, a decree, an imperial decree, a law issued by the emperor. Later, in the plural form, constitutiones, a collection of laws. It took various forms, including orations, the laws submitted to the Senate, and etica, laws usually of general character put forth by the emperor, mandata, administrative directives to imperial officials, decreta, decisions by the emperor in legal cases, and rescripta, the emperor's responses to questions posed by litigants or imperial officials. Over time, the rapidly increasing number of constitutions prompted their arrangement into collections such as the Theodosian Code and the Code of Justinian. They were the sole form of legislation after the 3rd century AD, also termed collectively Constitutions Principium, the Theodosian Code, Justinian Code. Okay. Applied to the lawmaking utterance of the Roman emperors. Had a very different word. But then here's Constitution right next to it. Okay, right next to it is the root of the word Constitution. The entire plan or philosophy on which something is constructed, the construct, the fundamental and organic law of a country or state that establishes the constitutions and apparatus of government, defines the scope of governmental sovereign powers, and guarantees individual civil rights and civil liberties. Okay, I'm going to look up this. I'm going to go over the civil service next. Okay, then the set of basic laws and principles that a country, state, or organization is governed by, the written instrument embodying this fundamental law, together with any formal amendments. Okay, there's a federal constitution, flexible constitution, rigid constitution, state constitution. Here's the United States Constitution. The 1787 document ratified by the original 13 colonies to reform and restructure the national government and establish the relationship between the federal government and the states collectively and the relationships between the individual states. Before the Constitution was drafted, the governing bodies were the Continental Congress and its successor, the Congress of the Confederation, sometimes shortened to the Constitution, also termed Federal Constitution. Then there's the unwritten Constitution. There's constitutional, adjective, of, relating to, or involving a constitution, proper and valid under a constitution. Then constitutional avoidance rule, the doctrine that a case should not be resolved by deciding a constitutional question if it can be resolved in some other fashion. Constitutional challenge, constitutional convention, constitutional corporation, constitutional court, see court or Article 3 court, constitutional doubt canon, the doctrine that a statute should be interpreted in a way that avoids placing its constitutionality in doubt, also termed presumption against unconstitutionality, or no constitutional doubt canon. See presumption of validity, presumption against ineffectiveness. Ure magi vale quam pret. Then there's the constitutional fact doctrine, the rule that federal courts are not bound by an administrative agency's finding of fact when the facts involve whether the agency has exceeded constitutional limitation on its powers, especially regarding personal rights. The courts reviewed the facts de novo to afford protection of constitutional rights. Although it has not been overruled or wholly discredited, this rule has fallen out of favor. The rule that a federal appellate court is not bound by a trial court's findings of fact when constitutional rights are implicated, specifically in citizenship determination and First Amendment cases. See example, Bose Corp versus Consumers Union, 466 U.S. 485 104 SC.CT.1949. Jurisdictional fact doctrine. Then there's constitutional freedom, 1822, a basic liberty guaranteed by the Constitution or Bill of Rights, such as the freedom of speech, also termed constitutional protection, constitutional liberty. There's a constitutional guarantee, a promise obtained in the United States Constitution that supports or establishes an inalienable right, such as the right to due process. Constitutional homestead, see homestead. Constitutional immunity, see immunity. Constitutionalism, The theory that a government should be based on a constitution. Adherence to this theory. Popular constitutionalism. Constitutionality, a noun, the quality, state, or condition of being acceptable according to a constitution. Constitutionalize, verb, 1831. To provide with a constitution, to make constitutional, to bring in line with a constitution, to make a constitutional question out of, to subject to the burden of passing constitutional muster, to lodge, at least in part on the basis of constitutional violation, as in an objection, hearsay, also confrontation clause violation, also termed federalize. Constitutional law, the body of law deriving from the U.S. Constitution and dealing primarily with governmental powers, civil rights, and civil liberties. The body of legal rules that determine the constitution of a state or country with an unwritten constitution. Statutory law, common law, the field of law dealing with aspects of constitutional provisions, such as restrictions on government powers and guarantees of rights. Constitutional liberty, see constitutional freedom. Constitutional limitation, a constitutional provision that restricts the powers of a government branch, department, agency, or officer. Constitutional majority, see majority of all the members under majority. Constitutional malice, see actual malice under malice. Constitutional monarchy, see limited monarchy under monarchy. Constitutional office, a public position that is created by a constitution rather than by a statute. Constitutional officer, see officer. Constitutional option, see the nuclear option. Constitutional power, a governmental authority or capacity that in a government formed under a constitution is enumerated or implied as being vested in a particular branch or official as a legislative, executive, or judicial power granted by or deriving from a constitution. Constitutional prohibition, see prohibition. Constitutional protection, see constitutional freedom. Constitutional question, a legal issue resolvable by the interpretation of a constitution rather than a statute. Constitutional right, a right guaranteed by a constitution, especially one guaranteed by the United States Constitution or by a state constitution. Fundamental constitutional right, a right that is specifically identified in a constitution or has been found to be protected under the Due Process or Equal Protection Clause. Constitutional taking, see taking. Constitutional tort, see tort. Constitution Day, see Constitution Day and Citizenship Day. Constitution Day and Citizenship Day, an American federal holiday to commemorate the signing of the U.S. Constitution on September 17th, 1787, and to honor people who have become United States citizens. Originally, the holiday was Constitution Day, 1911, the later also called Citizenship Day, 1952, and both were observed on September 17th. In 2004, it was renamed in an amendment to the Omnibus Spending Bill of 2004. Wow. Constitutiones Printium, see Constitutio. Constitution making, the drafting and bringing into effect of a constitution. Constitution maker. And then there's the Constitutions of Clarendon, a 12th century statement of customary law. And then it's the Constitutor, Latin, an orderer or arranger, a person who by agreement becomes responsible for payment of another's debt. Constitutum, agreed or arrangement, an agreement to pay an existing debt, either one owns or another's on a fixed day. Constitutum was not a novation. The creditor could still sue the original debtor. It differed from a stipulation because it had to be for an existing debt. If the promise was to pay one's own debt, it was called constitutum debiti properi. If this was to pay another's debt, then it was constitutionum debiti alieni, the fixing of a day for the repayment of money owed. And then constitutum possessorium, possessory agreement, a type of constructive delivery in which immediate possession is transferred while the immediate control or custody remains in the transferor. See mediate possession under possession, the agreement by which this transfer is brought about. In the context of a security interest, the pledged property may remain in the possession of the debtor, but as bailee of the creditor. For the other two types of constructive delivery, see attunement, brevi manu, also termed traditio longa manu. Okay, construction, the act of building by combining or arranging parts or elements, the thing so built. The act or process of interpreting or explaining the meaning of a writing, usually a constitution, statute, or other legal instrument. The ascertainment of a document's sense in accordance with established judicial standards. Interpretation, construct, construe. Okay, so that's from the Black's Law Dictionary, 10th edition. Okay, so this is Constantine. Just going to read you a little bit here. The Tetrarchy. Okay, look up that word. The first Tetrarchy, Jovians and Herculeans, the Caesars at war, the army of the Tetrarchs, the great persecution, Lactantius on the deaths of the persecutors. Okay, with a better understanding of the Roman Empire in the 3rd century, one can approach Constantine, who fused the vigor of the Christian faith with the power of the army. Constantine exploited the traditional interaction between faith and military power, the imperial theology of victory, to construct for himself the image of unconquered emperor. He took as his patron the greatest god, whose identity was revealed to him in a vision, and later, having established his hold on power, he transformed himself from unconquered emperor, a style enjoyed by so many of his predecessors, to Christian victor, a title unique to Constantine. His response, however, was not to the situation at the death of Aurelian, when Constantine was but an infant, but to that which prevailed in the first decade of the 4th century. At that time, the Roman Empire was ruled by four emperors, 2 junior with the title Caesar and 2 senior with the title Augustus. Together, they were known as the Tetrarchs. One of these was Constantine's father, Constantinus Chlorus, a junior emperor who was subordinate to Maximian. Into the west. To the east, the junior emperor was Galerius, subordinate to Diocletian. The first Tetrarchy, Diocletian, commander of the imperial bodyguard, was acclaimed emperor by his troops near Nicodemia in Bithynia, Izmit in modern Turkey, near Istanbul, in November AD 284. He attained power in the same manner as so many of his predecessors, but he retained it in a manner no other had achieved. Through the period of crisis, one of the commonest acts of a recent usurper was to seek recognition of his son as Caesar, which designated a junior emperor and heir, or occasionally as Augustus, co-emperor. Diocletian emulated this, but removed the dynastic element, and hence harnessed the dynasium of new men to the new system, obviating the tendency to place teenage puppets on the throne. Teenage puppets, eh? Such as the Servius Alexander and Gordian III. He could then campaign without the fear, which every one of his predecessors had felt, to which most of his had succumbed. That appointing a successful general was tantamount to signing his own death warrant. If the emperor himself could not win in all battles, and no man could fight on northern or eastern frontiers simultaneously, then he had better hope that he appointed general failed to win any spectacular then he had better hope that his appointed general failed to win any spectacular victories. According to a papyrus recorded from Egypt dated March 285, Diocletian was called Diocles upon his accession, but he took for himself the more imperial style, Gaius Aurelius Valerius Diocletianus. His first act was to dispose of Aper, the Praetorian prefect, with whom he had conspired to kill Numeranius, elder son of Carus, 282-3. Before May 285, Carus' second son, Carinus, was murdered by his own troops in Moesia. to avoid battle with Diocletian. I'm going to stop there and fast forward. Okay, here is the word Roman, romance, Romanes, romance, or Romanes. Okay. In the years after the Persian victory, Diocletian found himself with no military campaign to lead, nor one to plan. In 299, he had swapped stations with his victorious junior, shuttling between Antioch and Syria and Nicomedia and Bithynia. Galerius moved to Salonika, to live in the shadow of his arch. The Caesar had attained his prestige by his victory over Narses, that he eclipsed the Augustus. Clearly, Jupiter was working through Diocletian's subordinate, to the credit of both, but to the greater glory of the younger man. While Galerius ensured order at the Danube frontier, Diocletian toured the eastern provinces of the empire he had ruled for 2 decades. Now at peace, he was no longer young, and his attention had been fixed for some time on the type of empire he would leave behind. Unable to tame the economy, Diocletian turned his controlling urges to the state's moral and spiritual health, promoting a victive return to the traditional Roman values. Thus, in 295, an edict that's on the Supreme Court doors, edict issued in Damascus, specified that Roman laws of marriage were valid everywhere, and any unions contracted under the other conventions were not only void, but like the lustful promiscuity of cattle or wild animals. Conformity with Diocletian's notions of Romanitas or Romanes was to be ensured in the face of regional and local variation, even at the cost of social cohesion. The Augustus had only a poor, perhaps no knowledge of Greek, the language spoken by citizens in the capital of Nicomedia, and the lingua franca throughout the eastern provinces that he regularly toured. His Illyrian peasant upbringing and decades in the army camps made Latin his preferred tongue, and seeking to make a virtue of his shortcoming, he made the revival of Latin a core element in his program of cultural renewal. It had never been un-Roman to speak Greek, which was the core of a rounded education, but now all official business was to be conducted and recorded in Latin, even where all parties spoke Greek. The new emphasis on Latin was not to appear anti-intellectual. Professors of Latin were appointed in imperial capitals, and it is due largely to this revival that such a variety of Latin panegyrical material has survived. To elucidate and otherwise opaque decades of the Tetrarchy. Okay, I'm going to stop there. That's Constantine. Okay, I'm going to read you from the Latin dictionary. Okay, constitutio. Okay, the act of settling, settled condition, disposition, definition, a regulation, order, ordinance. Okay, constitutio, to cause to stand, set up, place, establish, to post, station, arrange, to set up the standards, drew up, to halt, to settle, to found, set up, to appoint to an office, to settle, to fix upon, to settle and arrange, to set up, establish, form, to decide, and decide. Okay, so that's the root of constitution. Okay, Latin dictionary. And then I'm going to read to you the Constitution book at the library. Admiralty and Maritime Law. The judicial power of the federal court shall extend, Article 3, Section 2 of the Constitution states in part, to all cases of admiralty and maritime jurisdiction. So that means all of them are commercial. Inclusion of this provision reflected a uniform desire to give the federal government jurisdiction over this important adjunct of commerce and trade, noted Alexander Hamilton in Essay 80 of the Federalists, 1787 to 1788. See Federalist Papers. Have not thus far shown a disposition to deny the national judiciary the cognizance of maritime causes. These so generally depend on the laws of nations and so commonly affect the rights of foreigners that they fall within the considerations which are relative to the public peace, see international law. Dealing with navigation, shipping, international trade, and seaports, admiralty and maritime law is a distinct body of law, admittedly a narrow field with little constitutional impact on the lives of most American citizens. It was, however, of importance to the framers of the Constitution, who had been called to the Constitutional Convention of 1787 to amend the Articles of the Confederation, largely in response to problems relating to trade and commerce among the states. Apparently, the Committee on Detail added the Admiralty and Maritime provision, but nothing in the convention records indicates any significant discussion about it. So they just added it. The Judiciary Act 1789 contained a broad grant of power to the federal courts, including jurisdiction over all civil cases of admiralty and maritime jurisdiction, and all seizures under the law of imposts, navigation, or trade of the United States where seizures are made on waters which are navigable from sea by vessels of 10 or more tons, as well as upon the high seas. Okay. And then here's common law communications. The ability to use complex language distinguishes humans from other animals, making communication the glue of human culture, religion, and social political organization. In a democracy, communication plays an especially important role through the free exchange of ideas, unhampered by government censorship or control. An informed electorate can make the decisions required under the Constitution. In 1787, the framers of the Constitution addressed communications only once in Article 1, Section 8, when they gave Congress the power to establish post offices and post roads. Several years later, the First Amendment, 1791, took up the important communications methods of the times, stating Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble, and to petition the government for a redress of grievances. Today, the constitutions of many nations specifically address freedom and privacy of communications. 2 of Sweden's 4 constitutional documents concern communications: the Freedom of Expression Act, 1992, and the Freedom of the Press Act, as amended in 1992, which provides that every Swedish citizen is free to publish his thoughts and opinions in print, and to make statements and communicate information on any subject whatsoever. Romania's constitution, Romania, states in Article 28, secrecy of letters, telegrams, and other postal communications, of telephone conversations, of any other legal means of communications is inviolable. Traditional forms of communication in the United States, such as religion, speech, the press, and assembly and association, are constitutionally guaranteed. The Supreme Court has held in several cases, including Martin v. City of Struthers, 1943, and Capitol Square Review and Advisory Board v. Panett, 1995, that the First Amendment gives broad protection to communication of religious beliefs against government censorship. Similarly, speech in the secular context is protected, especially where it can be defined as political speech. The sine qua non of a democracy, freedom of the press, and freedom of assembly and association to evolve traditional ways of communicating politically in a free, open, and democratic society, and therefore generally receive broad protection under the Constitution. However, the invention of radio and television, the telephone, and the internet has raised new questions regarding the constitutionality of government interference in or regulation of communications. Okay, wiretapping, Katz versus United States, 1976. Wiretapping of a public telephone without a warrant is invalidated. Okay. And then local government, state constructs. Remember, it's a construct. The U.S. Constitution is silent on cities, towns, municipalities, counties, districts, political subdivisions of state governments. Okay, so they have no territory over if you're in a town. If you're in an incorporated town, basically. Same thing with local elections. C. Hunter versus City of Pittsburgh. The court declared that political subdivisions of the state are created as convenient agencies. They're agencies for exercising such the powers of a state as may be entrusted to them. So that's something I hope everyone understands. Okay. There is a municipal spirit which sustains and gives them life. These are the local townships. They really don't have to listen to the Constitution. So that's from the United States Constitution, A to Z. It's a reference encyclopedia of American government. Okay. Love you. Have a great day. Taylor Madison, Colette Quinn, thanks for teaching Daddy how to win. Kathy Comboy, thinking about you. We're going to get to the bottom of this, Ma.